Good evening, everybody. Notice is hereby given that there will be a special meeting of the Zoning Board of Appeals this evening, Monday, November 25th, here at the Wiggin Auditorium in City Hall. Tonight we have a continued meeting, continued application of 40 Oak Street Development, LLC, for a Chapter 40B comprehensive permit application as it applies to the premise known as 40 Oak Street, Peabody, Mass., map 095, lot 089X. The petitioner seeks to construct 80 rental units. The property is located in an R4 zoning district. However, it has come to light to us, and this board has concerns that in order to move forward with this, somebody has to be in control of the property. And there is pending litigation that has yet been heard in the courts. So we feel, obviously, that there is nobody that legally owns the property at this point. And until it goes to court and a judgment is made, we are proposing this evening to continue all of this until February. A couple of the reasons are, and it makes perfect sense, if we were to hear all of this tonight as we were scheduled to, and one party loses in court and the property never gets sold. If somebody wins, then that's great, but we're not going to know that until the judgment in court is made. If we hear everything tonight and a judgment isn't made until March, you're going to have to do this all over again. So I would like one of the attorneys, maybe to, Attorney Smolak, if you would like to address any of these issues and agree to a continuance.
Good evening, Madam Chair, other members of the board. For the record, John Smolak, attorney for the applicant. This evening, this is the first time that I've heard that the board is looking to continue this hearing. The applicant has established site control. Site control is established and maintained under the project eligibility letter, and that is yet to be determined otherwise. So the applicant, just as background, the applicant has made several efforts to acquire the property without permits in place, and now the owners of the property are contesting the fact that we haven't moved fast enough. So I don't understand the logic of the action, but I could tell you, and Mass Housing will tell you, that we have established site control, and no one has indicated otherwise. So we'd like to proceed this evening.
Through the chair. Attorney Smolak, could you please let me know what the date of the project eligibility letter is?
Sure. The date of the project eligibility letter is March 21, 2017, and that project eligibility letter was also extended by date of March 8, 2019. So as long as we had filed prior to the expiration of that extended project eligibility letter, Mass Housing has determined that we have established jurisdiction for the board to hear this hearing.
Okay, well, the litigation that Madam Chair person was referring to is a 2014 court case in which there was a 2015 judgment in favor of your client.
Yes.
And that judgment came with an order for the sale of the property from the Elks to Larkin Real Estate Group.
Yes.
But also in compliance with the purchase and sale.
Mm-hmm.
And there was a term and condition in that purchase and sale agreement that time was of the essence.
Yes.
And it's been 6 years since the purchase and sale was signed. It's
Yes.
been 4+ years since the judgment was entered in April of 2015. And in October, just last month, I believe there was a motion for relief pursuant to Mass Rules of Civil Procedure, Rule 60, relief from the judgment filed by the attorney for the Elks, who I imagine would be here tonight, Attorney Oliveri. I think we'd like to ask him to come up and speak as well as to the status of that litigation, but I know that your opposing that motion, and you filed a cross motion for an order of the sale.
Well, I actually did not. I wasn't involved in the litigation. I was involved in representing the applicant with that matter. There's another attorney who had been involved.
In any event, there has been a request for a hearing made. I checked the docket today. I didn't see that a hearing has been scheduled yet, but I don't see any reason why we should go forward tonight beyond your presentation. In the event that your client is unsuccessful, we will have wasted everybody's time here.
Well, I'm not sure we're wasting anyone's time here this evening. I think the Housing Appeals Committee rules establish clearly that we have site control and that we should proceed for the hearing this evening and have the full hearing. I disagree.
Can you show us what you mean when you say that the housing rules say that?
We've established site control under 760 CMR 56. There's an establishment of there's a project eligibility letter requirement that requires one to establish site control. That establishment of site control was affirmed as a result of the extension of the project eligibility
Are
letter.
you telling me that you can't lose site control once you've established site control?
You can lose site control during the process. We have to come back at final approval to establish site control if we ever lost it.
Well,
And
this
we haven't
board's
lost it.
concerned that you've lost it
No, we haven't.
because
you
there's
prefer
pending
that we-
litigation.
Excuse me?
There's pending litigation.
It doesn't matter.
Well, this board feels otherwise.
Well, the board is, you or the board is incorrect about that because the project eligibility letter established the site control. Case closed.
Okay, well, we'll see.
What was the CMR that you cited? 760 what?
It's the Housing Appeals Committee regulations,
I understand that, but
5904.
okay.
That establishes the requirements for a project eligibility letter. One of those jurisdictional requirements is that you have maintain ownership of the property or control of the property. And that is established at the time that you file the application. Even if you, in the unlikely circumstance that you lose control of the property during the process, if it's reestablished during final approval, then you still have site control and you maintain the requirements of the project eligibility. And we haven't lost site control. Project eligibility is clear that we have maintained site control, and we have a purchase and sale agreement, regardless of any litigation. It's similar to someone bringing a title action.
It's a hypothetical then.
Sure.
Because while some of us are lawyers on the board, we may not be lawyers in your exact area of practice. We're trying to figure this out along the way with you in some respects. So let's say hypothetically you were to lose the hearing in Middlesex Superior Court, and the court found in favor of the Elks. What would that do for your site control?
It would do nothing until we were to come back and look for a final approval after a decision has been made by the board. Or if the matter is appealed to the Housing Appeals Committee, then we would have to reestablish that we have site control.
So is what you're saying is if you presented before us over the course of the next several weeks, and we make a determination, let's say for the sake of argument it's favorable to you, and you that simultaneously lose in Middlesex Superior Court, that you would then have to come back to our board for final approval, or you have to go back to somebody else?
We would go to Mass Housing for final approval if our hearing proceeded. If our hearing proceeded and the board included a condition that requires that we establish site control by the time that we obtain final approval, which again would have to be established at the time that Mass Housing would examine the decision that was made by the board or the Housing Appeals Committee and determine that we have established site control.
Forgive me for my ignorance on this aspect, but would that housing board, would they be able to trump a decision from a judge in the Middlesex Superior Court?
No,
if you
no.
don't own, I guess what I'm getting confused is, if a court says you don't own the property, how do you have site control if a court says you don't own the property?
Well, first of all, no court has said we don't have site control or ownership of the property. If we don't have site control over the property during the course of this proceeding, then the board could make a determination that we've lost jurisdiction to bring an action or to bring a hearing before the board. But site control is established at the time that a project eligibility letter is issued. So even though there could be a situation where the court could find adversely against us, if we were to reestablish site control in some circumstance, by the time that we would come back for final approval through Mass Housing as a subsidizing agency, then we've met our obligations under 40B.
Through the chair. Hypothetically, if you have a fully executed purchase and sale agreement, is that the prerequisite essentially? Now, what happens if a term and condition of that purchase and sale isn't met, and then you're found to be in default of a purchase and sale agreement?
The purchase and sale agreement, which establishes site control, is established at the time that a project eligibility letter is issued.
I understand, but you've also, just a few minutes ago, said that you can lose site control throughout the process.
Right.
So
And
what are some examples of how someone might lose site control?
a purchase and sale agreement could expire. The parties can re-enter or re-execute a purchase agreement.
Well,
But that's not the circumstance here.
I think
You're
the
talking
argument
about-
that the Elks is making is that the purchase and sale agreement, that is essentially what is driving that judgment, has expired. So I think we should call up the other attorney and understand the other
well-
side of the other side of the argument. That's what I would.
With all due respect, Madam Chair, we have not lost site control, no matter what the attorney who is representing the Elks has said, or will say.
Well, we did give you a chance, and you can
Okay.
come back if you want. Attorney Olivieri? To address some of these issues? Would you like to address any of these issues?
Yes, if I may. My name is Frank Olivieri, and I represent the Peabody Lodge of Elks. They opposed the application for a comprehensive permit. In April of 2015, the Middlesex Superior Court entered an order requiring the Elks Lodge to convey the property to the Larkin Development Company, subject to the terms of a certain 2013 purchase and sale agreement. That agreement provided that time was of the essence for the closing on the property. The agreement was also conditioned on Larkin receiving permits for the development of the property from this board. The Elks Lodge has filed a motion in Middlesex Superior Court requesting that the court's order requiring it to convey the property to Larkin be vacated for Larkin's failure to timely comply with the terms of the agreement. We're talking a period of 7 years. As part of Rule 9A for the Superior Court, I'm allowed to ask for a hearing, and I have requested a hearing from the court where they will hear arguments from both sides as to whether or not they should vacate the order requiring the lodge to convey the property to Larkin. My client has great confidence that the court will grant this motion, and this would effectively cause the agreement between the Elks Lodge and Larkin to become null and void, and without recourse to either party. This would mean that the Elks Lodge would not be required to convey the Oak Street property to Larkin, and Larkin could not in any way demonstrate site control through a purchase and sale agreement.
Chair. Counsel, is there any indication from the clerk, assistant clerk for the session that you filed the motion in as to when the hearing may be scheduled?
No, I haven't had any, and I've learned long ago that you don't call the clerk of the session and ask them when the hearing is going to be. They'll just put you off. If I had to estimate, I would, and I'm not held to it, I would say sometime between the middle of December and the middle of January.
Thank you.
Through the chair. When this motion was filed by you, obviously you had to serve opposing party under Rule 9A. I assume you've received their response and submitted all that to the court, correct?
Correct, as under Rule 9, Rule 9A requires
Oh, no,
you...
I'm familiar with it.
Yeah.
I'm familiar with it.
So they did respond, and I filed a reply to that response. And Larkin's attorney filed a SIR motion, which is in effect a reply to the reply. He has to get the judge's permission to file a SIR motion, and I haven't received anything in mail from him saying that he has done that.
Do we know which session this is in?
It's courtroom, I think it's the 610 courtroom session.
Okay. And knowing that this is before the board, obviously, actively. Has there been any discussion about filing this as motion on an emergency basis with the court? I understand that there's no other pending litigation that might warrant an emergency basis, but since it's before this administrative board, it might be worthwhile requesting this to be heard on an emergency basis by the court.
I didn't think to bring an emergency motion because I don't know if the Elks Lodge's motion fit the definition of what is an emergency, but I'll look into it.
I don't think it does fit the legal definition of what an emergency motion is. I'm just thinking this is a bit of an extenuating circumstance. We have a 40B application before a board, and at this point, and with all due respect, at this point, instead of several weeks ago or months ago, the motion has been filed now mid-hearing, essentially, that I just think it might fit into an exception to the rule in order to file it as an emergency if the court were made aware of this pending action here.
I'll certainly look into it immediately.
Yeah, and I forget who's sitting right now in that courtroom up there. I think it was Judge Henry recently. But the clerks over there might be willing to have a conversation about it.
Thank you.
I just want to state for the record just that I don't know who's going to win. I don't know if the Elks are going to win. I don't know if Larkin's going to win. I don't know if this judgment's going to be vacated or not, but I do know that it sounds like it's very much in dispute. It's very much in dispute as to who is going to come out the victor in this thing. And I just don't think it's worth everybody's time to sit here and listen to a presentation and have all the elected officials come up and speak in favor or against or offer their opinion and weigh in. And to have the abutters come in and speak in favor or against, just to find out potentially in a matter of weeks that this buyer isn't going to be the buyer, and they're not going to, and therefore wouldn't be the applicant, be able to be an applicant under 40B. And I guess we can bring the applicant's attorney back up, and he can educate me and the rest of the board as to why we should think otherwise. But I'm not convinced that we shouldn't continue this by anything that anybody said here tonight.
Through the chair, if I could, Madam Chairperson, I'm gonna weigh in. I'm probably not the only first guy to speak that's not a lawyer, so this ought to be something. I guess my problem is, no matter which way this goes, it's either going to be properly before this board, or it's not going to be properly before this board. If the decision goes in favor of the Elks Lodge, then this matter isn't even properly before the board, because the applicant doesn't have ownership of the property. So if there's any doubt in my mind, I'm going to say we recess this. I certainly don't doubt what either of the attorneys said. I'm sure they're very learned, but from somebody that's not an attorney, my concern is I don't want to hear anything unless it's properly before this board. And if I can't be sure that it's properly before this board, I really don't want to hear it right now until the decision's been made. Thank you.
Madam Chair, if I may respond. This matter is properly before this board. The entire purpose of the Chapter 40B process is to expedite review of projects to enable the creation and production of affordable housing. Does this mean that if someone files an appeal of a wetlands determination on a project, that you would stop review of this hearing process because of that? I don't think so, and this is the same thing. Until there's a court determination otherwise, we have site control. And so that's the reason why we want to proceed with the hearing process. Because otherwise, every threat and every claim, whatever its merit, is designed to slow down and prevent the creation of housing. That's the statute. That's the reason why the statute was created. And so I respectfully request that we proceed with the entire hearing process as originally proposed.
I don't mean to be fill in the blank. But you said you were worried about a slowdown of this process? So this has been going on for how many years?
Well, Madam Chair, if the board wants to vote to continue this hearing, I'm not going to grant the request to extend the vote, and we'll take the next step. We think we're in the position where we establish site control, and if the board feels otherwise, they can vote otherwise. And then we can come back and we'll go through the same process again in a few weeks. I'm not trying to be disrespectful, but the record indicates that we have site control no matter what someone claims, no matter what someone files. And all we're asking for is the ability to make our presentation during this hearing process regarding of what someone thinks the merits of their case is.
And
are.
through the chair, I'm not disputing what you're saying, citing the CMRs. The CMRs say what they say. I think our general concern, I don't want to put words on people's mouths, is that site control is, you believe you have it right now because of the condition, because of the letter, which appears to be accurate based upon the CMRs and what you've represented to us. But we've also had represented to us that it can be lost. And it seems to us that there is litigation pending right now that could cause you to lose it. So I understand what this, I shouldn't say I understand, I've been taught by you tonight what the CMRs say to an extent. And I guess my question is there something that addresses this specific issue? A case or some notation or footnote within the statutes of the CMRs that say what happens when it's contested? Like, do the proceedings have to be stayed until a determination is made?
Yeah.
Is there a potential abuse of process claim against opposing counsel and their client for attempting to delay? I just don't understand what we're supposed to do when there's litigation pending. We're not judges.
Yeah, no, I understand. Good question. The CMR doesn't address every particular circumstance. What it does establish, though, is the grounds for the issuance and the maintenance of a project eligibility letter.
It speaks to this?
This particular circumstance, I'm not sure right off the top of my head, but I can tell you that we have site control until someone tells us we don't have it. It's not a hypothetical. Again, it's a situation where, what if someone files an appeal of a wetlands order of conditions? Does this board stop reviewing because of that? I don't think it would. And this is the same sort of situation, in my mind.
That's a very poor analogy. This is going to court.
Well,
You know,
wetlands appeals go to court as well. If there's an appeal under the local bylaw, it goes to Superior Court.
we're going to recess for 5 minutes, please. We're ready to hear your presentation.
Thank you, Madam Chair. We're having a little bit of a technical problem with our initial presentation, and hopefully it'll be up and running very shortly if we could pause a moment or two. But what I can do while we're waiting for that is start a little bit in terms of our initial information in terms of presentation. If you give me 1 second. Sorry, just 1 second. Madam Chair, if I could just start with some introductions until we get our computer system up. For the record, again, John Smolak, attorney for the applicant, 40 Oak Street Development, LLC. With me this evening are members of the project team, several of whom you'll hear from this evening, including Michael Larkin and Patrick Larkin, principals of the applicant. Also with us is Eric Swanson of Hancock Associates, our project engineer. In addition, we have Andrew Zalewski of the MTO Group, our project architect, and Scott Thornton of Nass Associates, our project traffic engineer. For this evening, what we'd like to accomplish is to provide the board with a very broad brush general overview of the proposed project, with the understanding that more significant details will be filled in terms of layout, stormwater, landscaping, and traffic. But the primary purpose of this evening's presentation is to, again, provide the board with a general and the public with a very broad overview of the project. So first, what I intend to do is to provide you with a very general overview of project information in terms of existing conditions. Then I'll turn the discussion over to Eric Swanson, who will walk you through the civil site plans, utilities, and other design matters. That discussion will be followed by our project architect, Andrew Zalewski, who will walk you through the project architectural design, including proposed buildings, amenities, and overall layout. And lastly, we'll have our project traffic engineer, Scott Thornton of Nass Associates, running you through the traffic generation, circulation, and access matters. Then we'll conclude with some final thoughts and be happy to take any questions that you may have. So what I will do is I'll just, you have the PowerPoint presentations in front of you, which are going to be presented on the screen shortly. What I may do is just ad lib a bit and just describe a little bit about the general project details until the PowerPoint presentation is up and running. The property, as you know, 40 Oak Street and its general neighborhood is generally characterized by a dense mix of residential, commercial, industrial uses, which you typically see within the downtown Peabody area. The site itself, 40 Oak Street, is approximately 1.61 acres in size, and it's been owned by the Elks Lodge since approximately 1966. Just in terms of, to get your bearings, although we don't have the aerial in front of us, to the north of the rear of the site, the property is bound by Little's Lane, Elliott Place, along with single and multifamily units, and also land owned by the Peabody Historical Society, beyond which leads to Main Street, and that's the rear of the site. To the south of the site, or the front of the site, its property is bounded by Oak Street and residences across Oak Street. To the west, or the left side of the property is bounded by a series of residential dwellings, which access from Sanborn Street and then Little's Lane and Elliott Place. And then to the east, or to the right of the Elks building, as you're looking from Oak Street, the property consists mostly of vegetation and the backyards of mostly residential dwellings, which are located closest to Washington Street. In terms of existing conditions, and this is actually the fifth slide in the presentation that I have provided to you.
I hate to interrupt you, but
Sure.
the audience doesn't have
Right.
what we're looking at, so I think maybe get this up and running within the
Okay.
next 5 minutes, or
Okay.
I don't know what
Fair enough.
to tell you. Are you up and running? Imagine that. Oh, yes. We thought you were bringing a technical fellow. It's fruitless to make a presentation if nobody can see the drawings.
If we could just try a little bit more to see if we can get some visuals up there. Appreciate it, Madam Chair.
Attorney Smolak, you just went through a list of your team.
Yes.
Do we have a list of them? Do we have that list?
Well, they'll be presenting this evening. There was an initial list that was presented in the application. I think the only change is that Hancock Associates is the project engineers of record.
Would you mind maybe doing a list and
Oh, no problem.
sending it to Carla?
Sure, no
Thank you.
problem.
Okay, anytime you're ready to begin, whoever is speaking.
Apologies for the delay, Madam Chair and the board. So just to get back on track in terms of general site information, Andy, can you move to the second slide, the next slide, please? This slide itself, as you can see, is a view that looks to the site easterly from Oak Street, looking at the Elks Building in that location, just as part of the initial entrance onto Oak Street. Andy, the next slide, if you could. This next slide simply depicts a general area within which the proposed project is located. As you can see, the neighborhood is characterized by a dense mix of residential, commercial, and industrial uses, which you can see in the downtown Peabody area. In the middle of this plan, you can see the project site, which is, where you see that red dot in the middle on top of the Elks Building. The site is approximately 1.61 acres in size, and as I indicated before, it's been owned by the Elks since approximately 1966. Just to get your bearings, if we can go to the next slide, Andy. With reference to this aerial, which is more of a close-up view, as you see, the property is surrounded to the northeast or to the rear of the site by Little's Lane and Elliott Place, along with single-family and multifamily units, and also land owned by the Peabody Historical Society, beyond which leads to Main Street. To the south or the front of the site, property is bounded by Oak Street and residences across Oak Street. To the west or to the left-hand side on this, of the slide as you're looking from Oak Street towards the Elks Building, a series of residential dwellings which access Sanborn Street and then Little's Lane and Elliott Place to the rear. And then on to the right side of the site, to the east, the area is mostly consisting of vegetation and backyards of mostly residential dwellings which are located very close to Washington Street. And so there's a bit of a buffer in that location. And if you can go to the next slide, please. From this plan, which is an assessor's map, you can see the project site, which again is approximately 1.61 acres in size. You can see the existing Elks Lodge building along Oak Street to the front. That building is approximately 8,400 square feet in size based on city records. The remainder of the parcel is dominated by parking, and almost the entire site, or more than 85% of the site, is dominated by, again, parking and other impervious surfaces, with little else in the form of improvements. The site is also located entirely within the Residence 4 or R4 zoning district, within which the single-family, two-family, and multifamily residential use is allowed by right. In terms of the proposal that you're about to see, the project involves the redevelopment of 40 Oak Street into a multifamily residential rental community of 80 units, including a single building containing a total of 72 units with parking under as well as surface parking. The project also includes the construction of a total of 8 townhouse-style units in 2 separate buildings to the northeasterly or rear portion of the site, which serves as a transition between the multifamily building to the center of the site and single and multifamily units to the rear of the site. Of the 80 units, a total of 20 of the units, or 25% of those units, will be set aside as affordable units for persons earning no more than 80% of area median income, adjusted for family size. That means that 75% of these units will serve as market rate residential units. And consistent with the board's comprehensive permit rules, we'll work with the board to establish a PBD-specific local preference for the affordable units, up to 70% of those units, or the maximum percentage allowed by law, so that there could be some PBD-specific residency or usage or work-related requirements as allowed by the Department of Housing and Community Development. The project will also have a total of 126 off-street parking spaces, including service and garage underspaces, or an average of around 1.6 parking spaces per unit, which is a ratio that's generally consistent with projects of this nature in downtown locations such as these. In terms of the more 40B specific requirements, according to the latest DHCD subsidized housing inventory, the city of Peabody has approximately 9.2% of its total housing stock as affordable units, which means that at least as of the publication of this subsidized housing inventory, the city is about 163 units short. It may be less since this has been published, but that's what the record provides. If this project is approved, then all 80 units would count towards the city's 10%. It would put the city close to its 10% threshold, which, when achieved, would put the city more in control of whether it would entertain future 40B projects. We also note that when the city's subsidized housing inventory is recalculated in 2020 or next year, that the project will help the city achieve or approach its 10% goal, since as a rental project, all the rental units would count towards the city's subsidized housing inventory. In terms of the application that we filed, it complies with the requirements of the state comprehensive permit regulations under 760 CMR 56, as well as local rules, including a project eligibility letter that confirms that the project qualifies for a subsidy under the Federal Home Loan Bank of Boston's New England Fund, where Mass Housing would be the project administrator. That site approval letter or project eligibility letter also confirms that based on Mass Housing's review, the project's financially feasible within the Peabody market, the site's appropriate location for multifamily residential development and the use to be compatible with the surrounding uses. Since the site's within walking distance to a variety of professional, retail, and civic uses, the MBTA bus service is available along Washington Street as well. The project eligibility letter also says the conceptual project design is generally appropriate for the site, considering factors such as the architectural design, building placement, and the like. And in addition, project eligibility letter states the density proposed is standard for multifamily development in a downtown area. And as we've discussed this evening, the applicant controls the site by virtue of the purchase and sale agreement, a copy of which is enclosed within the application. We've also included other materials responsive or required to be submitted as part of the Chapter 40B regulations, including a set of preliminary site plans prepared by a civil engineer, report of existing conditions within the application, architectural drawings and elevations, tabulation of units and bedrooms, a preliminary utilities plan, the project eligibility as just discussed, and then a preliminary list of requested waivers from the city's zoning and other general ordinances. And we've also included a traffic report that has been prepared by Vanessa and Associates as part of your materials. So we feel we've filed a complete application. And what I'd like to do at this point would be to turn the discussion over to our project civil engineer, Eric Swanson of Hancock Associates. Thank you.
Thank you, Attorney Smolak. Thank you, Madam Chairperson, members of the board, for having us here tonight. For the record, my name is Eric Swanson with Hancock Associates, and tonight I'll briefly describe the site and civil engineering aspects of the project. Could you go back a slide? Yep. Yep, that's fine. As Attorney Smolak stated, the existing site is currently occupied by the Elks Lodge building and associated parking area. The site is mostly impervious with some landscape areas around the perimeter. There are existing municipal services, water and sewer, in both Oak Street and Little's Lane. There is also a storm drain line that traverses the site from Little's Lane to Oak Street. A portion of the property lies within the 100-foot wetland buffer zone associated with a small wetland area located on the Peabody Historical Society's property. The site is also located within the 100-year floodplain associated with Goldthwaite Brook. Could you move ahead a couple? One more. The project proposes to construct 80 apartment and townhouse units of varying configurations. The apartments will be in the larger building near the front of the site, where townhouses will be located towards the rear of the site. The site has 2 access points from Oak Street and secondary access to and from Little's Lane. There are 126 parking spaces proposed. Slightly more than half will be located under the proposed buildings. The drives and remainder of the parking area will be paved. Proposed utility connections for the buildings can be made to the existing services in Oak Street or Little's Lane. There should be a reduction in impervious area under the proposed condition. The stormwater management system for the project will reduce peak runoff rates and volumes. The stormwater management system will also infiltrate roof runoff and collect runoff from the paved areas prior to discharge to the municipal system. As I mentioned previously, the site is located within the 100-year floodplain. The floodplain elevation in this area is elevation 27, and the first floor elevations of the proposed buildings are approximately elevation 31. In the configuration shown on the screen tonight, there will be no loss of floodplain volume, but actually an increase in floodplain volume were the project to be constructed. With that, that's my brief discussion of the civil and site aspects, and now I'll pass the presentation on to the project architect, and he will discuss the architectural design aspects. Thank you.
Excuse me, sir, we're going to give you a microphone. If at all possible.
Someone else will have to do the laptop.
Could somebody help him, maybe? Anybody?
Bueller?
Hello. Okay, the first slide is the ground level structure. Because we are in a floodplain, we've limited the total area of the ground level structure. It's actually much less than the existing building. Basically, it's a small lobby, it's an elevator core, some stairways, and that's it. The columns are the little dots which actually hold up the building above the parking level. So that in the event of a flood, this would actually block less of the flood surge than what is existing on the site. Next. The residential level above the parking, you can see the apartments on the left are the apartment building. It's 4 stories. The units range in size from studios, 1 bedrooms, and 2 bedrooms. The buildings to the right, detached from the main apartment building, are townhouse structures. All the 3-bedroom units are housed in those townhouses. There's 4 units in each. The townhouses, we feel, are more geared toward the family residents. In the 40B process, the state does require a minimum of 10% of the units to be 3-bedroom units. So we are providing 8 of the 80 units as 3-bedroom. These are the layouts of the units in the apartment building. You can see the 1-bedroom unit at the upper left, 679 square feet, fairly generous unit. The 3 in the middle of the top and the 2 bottom are the 2-bedroom units. The one at the top is at the end of the building, so it has a little bit different opportunity for windows on 2 sides, so it's a more luxurious unit. And then the other 2 units are in the middle of the mix. And then the unit on the far right is a studio unit. It's we call it unit 0 because there's 0 bedroom, but it is a studio type unit. If you go back one slide. I'd just like to show, we did mention there are 2 access points from Oak Street. The plan of the circulation is to have entry at the upper one so that as people would approach the building, see the signage, they would then turn into the driveway. That would be wide enough to be both an exit and an entrance point. The point on the bottom we would designate more as an exit point. It's a narrower driveway. Again, I think as people approach the building, and in my opinion, it's better to see the building first and then know that you make the right turn rather than missing the driveway, saying, oh my God, I'm past it. That's the thought that's gone into it. The exit out to Little's Lane is not to be used on a daily basis. That is really for an emergency. Fire department would be able to have another access point to the property. The townhouse units also have parking underneath, just like the parking under the main apartment building. Okay, two slides. Yeah. This is the facade of the apartment building from the westerly side, the main facade. You can see the entrance area. The rest of the building, again, because we're designing in a potential floodplain, is open. The automobiles can park underneath, but there is no doorways or gates or things to block any potential flood event. I keep talking about flood, and it is a little extreme, I think, because as far as we can tell, there has never been a recorded flood on this property in any kind of the insurance history that we've gone through. However, because of the elevation of the site, it is on the map as a potential flood area. Go ahead. The opposite side of the building is similar. It does not have the entrance lobby, so it does have the cars underneath. The proposed street elevation is a little bit misleading in my work because there is actually a berm proposed in front of the building. So what will be seen from the street is the upper part of the building. The parking will be partially obscured by the berm. The berm will be almost high enough to disguise it completely. Go ahead. The townhouse layouts, again, on the left, you can see the cars can park underneath. There is a stairway and a lobby that goes up. The main floor has the kitchen and living room, and then the upper floor has the 3 bedrooms. I have reviewed this with the Architectural Access Board, and they said that we can comply with their regulations if the stairway is wide enough to provide a chair on a rail that would travel up and down the stair. So it does allow us to do all the 3-bedroom units in a separate area. They're also in an area where they would have more access directly to the outside. I think it's a better solution for that type of family dwelling unit. Again, the elevations of the townhouse, it's a 4-unit building. It is hopefully designed to look like a larger traditional home. It has a little different look, but it is complementary to the apartment building. I think you can go on. Okay, this is the 3D model that the rendering is based on. It is a view where you can see how the townhouse buildings relate to the apartment building. This is an aerial view from the west side of the property. I think you can see the entrance area, how it is accentuated by the roof details. And you can see how the detail of the building itself is reminiscent of many of the townhomes with bay windows, materials that are very residential in nature. Okay, go from there. Again, an aerial view of the model so you can see how the buildings do relate to the surrounding neighborhood. That's Washington Street along the upper part of the view and Oak Street to the right. The site itself is colored tan, but I think the engineer's plan using the green was a little more accurate of what we're proposing. We will have a beautiful landscape plan of the entire site. Okay, I think that's the end of the architectural portion. We can go from there.
Okay. Good evening, Madam Chair, members of the board. My name is Scott Thornton. I'm with Vanessa and Associates. We prepared the traffic assessment for the project. I'll give you a brief summary of our findings. First off, the traffic study is a standard traffic impact assessment consistent with state and local guidelines. We discussed the scope of the study with city staff, including the police chief, representatives from community development, planning, and I believe conservation were there as well. I just want to give you an overview of the traffic study process. Is there another slide? Well, that's fine. So I'll go over the study area. We had mapped out 7 intersections for study with the town staff, basically extending from Washington Street to the east along Oak Street out to Foster Street. It includes Aborn Street, the 2 site driveways that are existing under current conditions. We have Sanborn Street, Winter Street, and then at the end we have Foster Street. All these locations are unsignalized. At some locations there's always stop control. For instance, at Winter Street, the intersection of Oak Street and Winter Street is always stop control. At Foster Street, it's 2-way stop control where Oak Street is under stop control. Foster Street continues as the right-of-way. Sanborn Street has no control at the moment, no stop signs present. So we did traffic counts at these locations in March and June, and we did those counts when schools were in session, so we obtained a pretty accurate representation of traffic flow in the area. We also looked at crash data for those intersections, and we identified that at 6 of the 7 locations, the crash averages are below the state averages for unsignalized intersections. And at the 7th location, which is Aborn Street with Washington Street, the calculations might be slightly skewed because of the low traffic volumes, but of the crashes that were observed there, about 7%, only about 7% involved injury, and there were no significant crashes at any of the study area locations. We also measured speed on Oak Street. It's not posted, but it's assumed to be 30 miles an hour, consistent with a densely developed location. The average speed that we observed was 24 miles an hour. 85th percentile speed was 28 miles per hour, and that's what's used in a review of site distances. And looking at the site driveway locations on Oak Street, they meet the required site distances as advanced by review agencies. And could I get the next slide, please? Wow. So, we identified, actually, could you back up? Well, actually, no, that's fine. So we looked at the ITE trip generation manual for estimation of the project trip generation. And based on the 80 units that are proposed with a slight adjustment for transit based on the Peabody census data, we expect during the morning and the evening peak hours. During the morning peak hour, we would expect about 36 vehicle trips, 6 entering, 30 exiting. And then in the evening peak hour, we would expect about 56 peak hour trips, 36 entering and 20 exiting. And again, these are based on the ITE trip generation manual, which is a standard source. It's required use for traffic assessments that are conducted for state review purposes and required under Mass DOT guidelines. So we take the traffic volumes that we observed and that from the traffic counts, project them out 7 years into the future, include background growth, include background development projects that we obtained from based on recommendations from your staff, and then we take the project traffic and add that on top of the future traffic volume conditions. Andy, the next slide, please. So then we do a level of service analysis, and that gives us an idea of the relative impact of the project compared with future no-build conditions and existing conditions. And you can see at the locations that we reviewed, there's really no change in level of service as a result of the project. The only location where there is a slight increase in delay is at the Oak Street and Foster Street intersection during the morning peak hour. You can see it goes from level of service D during the morning, which is the top row, on the no-build condition, level of service C in the morning condition under no-build, to level of service D in the morning under the build condition. That equates to about a 2-second increase in delay, which is minor, and a level of service D is perfectly acceptable for a urban condition during peak hours of analysis. So,
Excuse me.
Sure. So those are levels of service, and they're broken out or disaggregated into different ranges of delay. So level of service A, for instance, is 0 to 10 seconds of delay. Level of service B is 10 to 20 seconds. Level of service C is 20 to 30 seconds or about of delay. So when you get up to level service F, those conditions are much higher, represent much higher delays associated with the movements. And so these, with unsignalized intersections, the level of service represents the delay associated with the movement that's under stop control. So obviously there's minimal delays on Washington Street and on Foster Street, but the delays coming out of Aborn Street are significant due to that street's use as a cut through. Some of the other locations are, at Sanborn Street, we tried to, it's not really under any control, as I mentioned. It's not under any stop sign control, but we assumed that it was under control for this analysis, just to provide a consistent basis for comparison. So if, Andy, could we look at the next slide? Wow. Okay, let's go back to the other one. So that's the conclusion slide. So the site distances meet or exceed industry guidelines. The project is within a quarter mile of MBTA bus service on Washington Street and within 2 miles of the Salem commuter rail station. Represents a minor increase in traffic volumes between 0.1% and 1.9%, depending on location. The net traffic increases are equivalent to 1 to 2 vehicles or a vehicle every 1 to 2 minutes during the peak hours. Project doesn't cause a decrease in level of service at any of the locations, or at 6 of the 7 locations looked at, and at that 7th location, again, it's just a 2-second increase. And while the project does represent an increase in traffic compared with the current use, in relation to increasing distance from the site, the delays are manageable, and as you get further out from the site, it'll be less noticeable.
Through the chair, while you're still up here.
Sure.
I'm just curious how you came up with the number 7 intersections. Have something to do with the addition of 120 cars? Did it have something to do with the distance between the site and the intersections? Why 7? Why not 5? Why not 10? And why those 7?
Sure. So we basically, we looked at that Oak Street corridor from one end to the other, and these were the locations that that city staff recommended that we look at.
You all set, Dan? Yeah. Just through the chair. Ms. Thornton, I understand you studied the intersections. Has there been any study, or is there even an ability to study the impact on Washington Street itself? Because Oak Street's one way off of Washington,
Right.
so you can't enter back on that way, but that is a pretty heavily traveled street, and I wasn't sure if there was a study to determine how that would impact people's travel to and from Main Street downtown, or towards Salem or from Salem, with the introduction of these additional 50 or so vehicles during evening peak.
Yeah, so we did look at the left turn from Washington Street into Oak Street, and that had really a minor, the project increase, or project traffic was really minor in comparison with what's there now. We didn't go look further down Washington Street or onto Main Street because our study area was really focused right on Oak Street.
That turn was the left-hand turn coming
North
coming
on Washington.
northbound. Okay,
Yep.
thank you.
Through the chair, if I could, please. I'm kind of interested in Little's Lane and why that wasn't chosen. If you could tell me, and I know it was said that it was not meant to be used only for fire and emergencies, but how are you going to restrict that from being used by the residents?
So the architect is indicating there would be gated, there would be a gate across the Little's Lane access?
Okay, similar to the one that's there now. Okay, I hope they get a new one anyway. Thank you.
Through the chair, how would the emergency vehicles access that if there is a gate? What's the,
Are there any other questions, or should I turn it back over to Attorney Smolak?
I just have a comment on something you commented on. I have a comment on something you commented on. So you made reference to, you didn't think this area flooded. I think that the ward councilor and anybody that lives in the area, I don't live in that area, but I can see it on TV. It floods so much they can canoe on it. Canoe? It floods, just so you know, badly.
Madam Chair, that concludes our presentation, except that in sum, I think that the site is an excellent location for this type of residential housing. And in fact, the city's prior housing production plan, I cited this site as an example of an ideal location for housing in this area. The city's new housing production plan says there's a significant need for rental housing and also ownership housing in the city. Again, there's a clear demand, like many cities and towns, for additional housing, both rental and ownership. And we certainly think that this proposal will fill that need. We look forward to working with the board and the public to work through all the various wrinkles that we'll have to work through and to demonstrate that we meet the applicable performance standards, and look forward to working with you on that. Thank you.
Just one, there is a letter from our building commissioner, Mr. Al Tellerico, who is requesting for you to reach out to him for a third-party review before he issues any building permit. I know it's very premature, but it was issued today, just so you'll know.
No, I appreciate that, and I'm glad you mentioned that as well. And if I could just mention something before you go to additional comment, is that we appreciate that Mr. Bellavance has secured peer review consultants for this project. What we'd like to suggest is between now and the next hearing, whenever that hearing is that perhaps the board's consultant, Mr. Beals, and Mr. Bellavance, and our project architect, our engineers, and traffic consultants can get together to make sure that we're on the same page in terms of the scope of review. Because as you know, the nature of peer review is reviewing the technical material provided by our project team, and there are some items that are identified in the scope as sort of a new study. And so we'd like to work through those wrinkles, not in the hearing process, but maybe between the professionals to clarify those items to ensure that we're covering the scope that's needed to be covered and by whom. So
Mr. Bellavance is here. Would you like to comment on that, or would you like Attorney Smolak to send something to you through email about how could you do that?
Sure, and also,
Whatever you wanted Mr. Bellavance to do, just email it to him.
sure, we're happy to do that, and to the extent that the board is willing to allow to have either a conference call or a face-to-face discussion about sort of these scopes, would the board be willing to allow that to happen? And we could report in
Fine.
on that as well. We just want to try to make that work smoothly. Thank you.
Okay. Presentation's finished, correct? Yes. Thank you very much. Very informative. Barry? So we're going to go on with a few other housekeeping issues. Are we all set with Mr. Osborne's disclosure? So Attorney Smolak, we do have a signed disclosure from Mr. Osborne saying that he's all set, and you're all set with that, with his... You remember what we're about?
I guess I haven't seen that, but I'd like to reserve comment on that, and I'll take a look at it and then get back to it at the next meeting. Has the city solicitor reviewed that as well, or had discussions? I just don't know, because
Okay,
we just want to make sure.
We'll get that to you.
Okay. Thank you very much.
All right, at this time, I believe we will hear from any elected official that would like to speak for, against, comment, thoughts, issues, non-issues. And we have Councilor McGinn.
Thank you, Madam Chairperson. My name is Pete McGinn. I am the Ward 2 Councilor, City of Peabody, and I represent the portion of the city where this parcel is located. Simply put, 40 Oak Street, for a variety of reasons, should not be residentially developed. The attempt by the applicant to develop this site dates back to 2013. Abutters were opposed to attempts by the applicant to obtain permits from the Conservation Commission. When it became clear that the Conservation Commission would not likely grant the order of conditions in 2015, the applicant withdrew from that process. The applicant then went in the direction of a 40B development. The 40B proposal is even more detrimental to the area than the original application. Many of the same abutters that were attentive to the process back in 2014 and 2015 are here again. However, some are not. That is not because they have changed their opinion on the site, but rather because they have become fatigued by a saga that has now played out for over 6 years. There are several criteria that must be satisfied to obtain 40B project eligibility, and that was discussed. One of those was discussed by the board earlier this evening. On that list is site control. The applicant's control of the site has been in question in my mind for quite some time. Based on my understanding of the Elks Court filings, they seek to nullify the purchase and sale agreement, which dates back to 2013. The applicant is using the attempt to obtain permits under 40B as a means of leveraging site control from the Elks. Thus, rather than the applicant demonstrating site control as a precondition of 40B project eligibility, they are using 40B to leverage site control, which is a perversion of the process. The ZBA should not be party to this twisting of the process by allowing this to continue. I know that you looked at, or you had certain aspects of the law cited to you tonight. My read on the law is somewhat different in terms of what the ZBA's authority is under these circumstances. Under 760 CMR 56.04, subsection 6, conclusive nature of determination, I'm going to read a section of that. Alleged failure of the applicant to continue to fulfill any of the project eligibility requirements may be subsequently raised by the board at any time, and the board in this context is the ZBA. Solely upon the grounds that there have been a substantial change affecting project eligibility requirement as set forth in 760 CMR 5604 subsection 1. And the board hearing may be stayed until the challenge is decided. So I would argue that it is within your power to challenge site eligibility, but I would certainly defer to the wisdom and judgment of this board in terms of how to proceed or not. I would just say in my search of the public records, I have found that the Elks have filed with Middlesex Superior Court. I think that was established earlier this evening, and I suspect you'll hear more about that from the Elks attorney tonight if you choose to have him back again at to make further comments. All of this is just a clear indication to me that the applicant's claim of site control remains in doubt. And I would also submit to the ZBA that when the project eligibility extension was issued by the subsidizing agency, Mass Housing, neither the city, the municipality in this case, or the property owner was given any notice of the request to extend project eligibility and make known to the subsidizing agency that there may be a substantial change in circumstance. In 2016, along with 20 other submittals from elected officials, department heads, boards and commissions, abutters, and other interested parties, I submitted my feedback on this project. My submission was in my capacity as ward councilor of the area in which this parcel is located, and at the time, as city council president. All of this documentation has been resubmitted by the mayor to the ZBA in his communication dated July 19th, 2019. I anticipate all of this potentially additional information will be presented by those who originally submitted the information into the package in 2016. My submittal was 26 pages, and it was labeled Attachment 2. The first of the three sections in Attachment 2 dealt with site control, related applications, and municipal actions previously taken to meet affordable housing needs. At this point, I would assert that the focus should be on site control, as previously stated. The remainder of Attachment 2 provides information detailing why the project is not generally appropriate for the site on which it is located, taking into consideration proposed use, conceptual site plan, building massing, topography, environmental resources, and integration into existing development patterns. Building massing of a 5-story, 62-foot-high, 72-unit apartment building in conjunction with 2 3-story townhouses, which adds 8 apartments, is completely out of scale with all residential development in the immediate area, where the norm is single, 2, and 3-family residential. The impact on the abutters' quality of life, including matters of privacy and shading, to list only a few factors, are simply unacceptable. Additionally, such proposed building massing is completely out of character with those properties directly adjacent to the site in the abutting National Register of Historic Places, Washington Street Historic District. The site is almost entirely in the FEMA Flood Insurance Rate Map Special Flood Hazard Area, SFHA, Zone AE. Frankly, the assertion earlier by the architect that the area doesn't flood is laughable and somewhat insulting. Zone AE is defined as an area inundated by 100-year flooding from which BFEs, or base flood elevations, have been determined. The site has flooded, as have other areas in the vicinity in the same SFHA that have notorious flooding issues. According to older, longtime area residents, the site flooded even prior to the addition of an impervious parking surface. Thus, I take no comfort in the assertions that a reduction in impervious will improve the site's performance. Natural environment combined with development have created ideal conditions for flooding in this flood zone. There are pictured records and accounts of floods in the flood zone dating back to 1902. Since 1954, this flood zone has suffered severe flooding 15 times. There have been flooding events in this flood zone in 1954, 1968, 1979, 1987, 1996, 1998, 2001, 2004, 2006. There were 2 separate events in 2010, 2011, and 2 separate events in 2014, and one as recently as 2018. The floods of October 1996, April 2004, and May 2006 were declared federal disasters. There exists a great deal of photographic and video evidence of many of these flood events. I will submit photos of the August 2018 event under separate cover. In 2011, the city estimated that the city incurred $12 million of damage from the Mother's Day flood. In May 2006, another $2 to $3 million in flood damage in 2010. These costs included damaged businesses, emergency response, lost property, tax revenue, and downtown vacancies. According to the Peabody's Department of Public Services, the city has tried to deal with the issue as far back as 1956, when one of the first studies took place. While some mitigation efforts have been made, large-scale flood mitigation measures recommended by experts are estimated to cost in excess of $30 million and remain unfeasible for Peabody to undertake. It is a statistical certainty that the site will flood in the future, and scientifically established environmental factors including sea level rise and an increase in heavy precipitation events will intensify flooding conditions. According to the Massachusetts Executive Office of Energy and Environmental Affairs and the Massachusetts Office of Coastal Management, the documented relative sea level rise rate in Massachusetts is approximately 1 foot rise for every 100 years. This rise will exacerbate flooding events. Heavy precipitation events are expected to increase between 2016 and 2035, as corroborated by information I submitted supplementing Attachment 2. This increase in heavy precipitation events will worsen flooding events. In March 2019, as a function of Peabody's participation in the state's municipal vulnerability preparedness program, Peabody prepared a resilience evaluation report to evaluate impacts of climate change. Although the study area did not include the 40 Oaks site, the study area did include a portion of the same SFHA Zone AE in which 40 Oak site is situated. Among the study's findings were that Peabody Square, which is already prone to significant flooding during storm events, could experience even higher likelihood of extreme flooding under scenarios involving both high tides and extreme precipitation. One of the alternatives suggested by the report is a retreat strategy. As the state of Massachusetts sponsored report indicates, retreat from such flood-prone areas is a prudent approach, then clearly the city's ordinances are sound in that regard. Any plan that puts additional residential tenants in harm's way, including elderly, children, and individuals with disabilities, is neither responsible, ethical, or on the part of the developer, nor fair to the municipality that would have to render emergency services during flood conditions. Post-flooding environmental impacts are prone to mold and other contamination, which represents further health risks. Peabody's ordinances stipulate that land subject to seasonal or periodic flooding shall not be used for residences or for other purposes when such use will endanger the health or safety of the occupants thereof or the public generally. This life safety provision must apply in all cases, and even more so going forward as these risks increase with the effects of climate change. Under flooding conditions, people and automobiles will need to be evacuated. There is no area in the vicinity capable of accommodating the 126 cars that would need to be moved during a flood event. The grade level elevator stop would have elevated doors opening at flood level. Peabody's ordinances establish as a purpose to minimize future flooding damage by providing for protection and retention of existing watercourses, water bodies, and wetlands. Given Peabody's, and in particular this flood zone's history of flooding and the associated resulting damage, this provision must apply in all cases. The site is, as we heard earlier, is directly adjacent to a wetland resource within the same Zone AE special flood hazard area. The proposed development encroaches on and threatens this important natural environmental resource. The applicant is requesting a waiver from many of the local ordinances. Where those relate to flooding and wetlands, the city is being asked to utilize the state's criteria. However, the Conservation Commission must still perform those evaluations. Within that requested waiver list, there are at least 4 that directly or indirectly reference Massachusetts Wetlands Protection Act, General Law, Chapter 131, Section 40. Thus, a significant portion of this matter needs to be adjudicated by the Conservation Commission separate from this ZBA process. According to older longtime residents, prior to its acquisition by the Elks, a portion of the site was used as a commercial auto body repair garage. Such a use raises concerns about potential existence of contamination on the site, which has not been evaluated. The applicant indicates that there are no documented hazardous waste sites within a half-mile radius of the site, no evidence of underground storage tanks or releases of hazardous materials, including hazardous waste, on the site within close proximity to the site, and no above-ground storage containers with flammable or explosive petroleum products or chemicals on or within a half-mile of the site. Given Peabody's industrial past, including the former leather factory sites on Winter and Spring Street in the vicinity of this site, and the site's proximity to an active IL industrial zoning district, these claims are highly suspect. This assertion is supported by the fact that in 2015, the U.S. Environmental Protection Agency awarded Peabody and Salem a grant to establish a revolving loan fund to support environmental remediation of brownfields. This site is surrounded by narrow and primarily one-way streets where existing residents utilize available limited on-street parking. Congestion worsens in winter conditions with snow and snowbanks. The proposed development contemplates little to no space for the storage of trash and recycling and snow. Thus, higher numbers of truck trips will be required to remove such materials. Traffic volume from residents and visitors to the proposed development, in addition to trash and other service vehicles and school buses, are not supportable on these roadways. The most direct pedestrian access from the site to Peabody's downtown Main Street is up a narrow one-way lane with insufficient width to accommodate a sidewalk, which would represent a safety problem for pedestrians seeking access to this commercial area. While the applicant indicates that the closest office industrial area are 0.6 miles from the site, such uses are actually much closer on Oak and Winter Streets in an IL zoning district. One of the businesses in the IL district is a trucking terminal on Winter Street, for which noise-related complaints from area residents are common. While the applicant indicates that the closest house of worship at 0.7 miles from the site, such a use is actually much closer on Elliott Place, the Congregation Sons of Israel Synagogue, which has no off-street parking lot and adds significantly to street congestion when in use for gatherings and services, particularly on religious holidays when the Elks have, in a neighborly fashion, permitted worshipers to utilize their parking lot. There are no parks or spaces in the immediate area where children can play. This lack of recreational space in an area caused children to play on the streets, and the development of this site would intensify this unsafe condition. The existing area congestion and one element of its associated life safety concern was vividly demonstrated in June 2016 when a 4-alarm fire destroyed a 3-family residence at the lower end of Little Lane and Elliott Place. That fire, which rendered 6 residential units in 2 buildings uninhabitable, was fought by the fire department from multiple area communities, primarily from the site of the proposed development. The proposed development will significantly increase congestion in the area and on the site, with portions of the proposed development 2 feet off the property line, such that emergency service providers would have no access no access point to the rear of the building due to the proximity of the wetland. Grammar school-age children that reside at the proposed development would need to be accommodated at the Welsh School, which is currently operating at or near full capacity. And lastly, a number of significant infrastructure issues raised by the Department of Public Services and other groups that have provided comments have not been considered in the budgeted construction costs provided by the applicant, rendering the financial assessment incomplete and consequently inaccurate. Thank you.
Thank you, Councilor. Any other city councilors that would wish to speak?
Good evening. Thank you for the opportunity to speak. My name is Ryan Melville. I'm a counselor at large. I also live within a mile of this proposed site. I wouldn't begin to try to explain the technicalities that clearly this board has done its due diligence over the years, and if you've watched any of the hearings regarding this, including tonight, I think the city of Peabody is being well served by this board and all the homework and diligence that it has done to inform the public and the residents that have come here to see this proceeding take place. But speaking of the residents, I can tell you that, following up on Councilor McGinn's comment, that there is a bit of fatigue with this particular issue. There's been, and based on the process that is taking place, residents are not sure when they can and can't come to comment, particularly this project, based on the technicalities and how long the range is on this, going back 6 years. But I think we're being well served by this board and the questions that you're asking in their place. A couple things I just want to comment on. First, the city of Peabody has taken on the challenge of housing, and between our zoning overlays and the approvals that the council, along with conjunction with this board, have made, has proven our investment in affordable housing and housing in the city as a whole. So I don't, when 40B when the statute came about, it was based on communities that might have been ignoring that. We're not doing that. The city has taken that position that we want affordable housing and we want it in the right places. A couple of concerns, Councilor McGinn touched on them, for residents in that area like myself. First is public safety. Ward 2 is probably, along with Ward 3, so that Tremont Street, Walnut Street, Foster Street, Washington Street, that area is the densest part of the city that we have. If you look at this project, my concern is, how do we deal with any sort of emergency situation there, whether it be a fire? I think we all remember roughly 10 years ago, a new construction that was taking place off 128. We remember a big fire broke out during that construction. So this isn't to say that modern materials will prevent that. And I think I'm concerned about the denseness of that neighborhood and how our fire department, our emergency personnel can deal with an emergency at that location. It's very hard to get to. It's very hard to organize in, especially in winter conditions, or if there's an event going on in the area, parking is at a minimum. Second thing I want to talk about is, as Councilor McGinn spoke to, is it's not just an impact in the immediate abutters, but it's going to be an impact that's going to kind of resonate out a mile or two in either direction. And Councilor McGinn touched on the Welch School, which I can tell you is going through a major renovation, and an influx of more students, more families in that area could have a detrimental impact on that particular institution. And lastly, I just want to say that the flood mitigation issues that we're seeing are based on smart growth decisions the city has made in the last 25 years. The investment the city has made to mitigate flooding in the downtown area has seen some results, but we've also gotten lucky with the storms and the issues that we've seen. I can't imagine how this particular project is going to help that issue. I know that every time as a counselor we have attorneys and architects and engineers come in, they'll tell us how, well, if we do this X, Y, and Z, the technology that we're going to put in there is actually going to make it better than it is right now. However, the maintaining of those systems is the long-term problem that we have. And we, time and time again, in projects that have been approved the last 20 years, you can go back and see that flooding has not improved based on those areas because the maintenance hasn't taken place. It's a fire and forget situation. They build it, maintain it for a year, they sell it. It's the next person's problem. It's our problem to maintain and tell those property owners to maintain the systems that they had promised to do. So it's something I've learned the last couple of years of being on the council that can impact that entire area. So in closing, I just want to thank this board for everything you're doing. It's an educational process to listen to you ask the questions. I really appreciate that. And as a counselor, I am opposed to this location and the development that is being proposed right now. Thank you very much.
Thank you, Ryan. Councilor Rozignol.
Thank you. Thank you for allowing me to speak this evening. When this first got proposed, it was about 6 years ago, and I was on the school board. And unanimously, we wrote a letter in opposition of this project, and the reasons being that was already stated by Councilor Melville as well as Councilor McGinn, were the size and scope of this project would have an adverse effect on the school system. It is too big of a project to, for us to house that much of a population influx. To me, to be perfectly honest with you and be perfectly blunt, this is almost an end around to apply for a 40B as opposed to go through our own zoning ordinances. Our own zoning says that you need 1.8 parking spots as opposed to 1.6. This is absolutely in a flood zone. As a kid, my father was an Elk member and I grew up in that building, and to say that that property does not flood is laughable. And not only that, but to that point, where the townhouses are proposed to go, floods the worst. It's the back far right corner if you're looking at the Elks building. So you're putting people in harm's way, to be perfectly blunt. Lastly, or actually two other points. Obviously, their proposal is to have a gate in the back for fire truck access. That to me says that there is no access surrounding the building as is. So if you're one of the residents in the middle of that front building, you're going to have to, the fire engines are going to have to come in Little's Lane in order to access that property. And the truck is not, there's no way a fire truck is going to be able to access the entire surrounding of that first building. By looking at that design, I just don't think that that's possible. The other thing that wasn't mentioned at all in this proposal was plowing. We get snow. Where is their snow removal mitigation? Where is their snow piles, and where are they going to be housed? And the last thing I'm just going to mention briefly is traffic. This proposal had nothing to do with the intersection at Washington and Foster, which is going to be one of the major access points from this new development. And every piece of that development had an increase in traffic. When the developer mentioned that there's only going to be 36 potential increased traffic, when you're talking about 80 residents, so only 36 work, when he was talking about peak access in the morning, that to me did not make any sense. I hope that there will be a third-party traffic study done and not rely on what the developer has brought to us today regarding traffic. I'm not as eloquent as Councilor McGinn, but as Councilor Melville had mentioned, I am on the City Council, and if this does come before this is not a proposal I think is appropriate for our city because of the size, the scope, and building in a floodplain. Thank you.
Councilor Rozignol. You know, as you were speaking, I just have one question. I don't think that any of the presenters touched on trash, dumpsters. Where were they going to be? How many? How are they going to be serviced?
Andrew Zaleski, I'm the architect. In this development, as in many of our similar developments, we typically do private trash collection. It's much more efficient than relying on the municipal trash. Trash will be kept in an area inside the parking garage, and when the private trash pickup is scheduled, it'll be brought out for them. So there won't be any open dumpsters around the site. It's actually very well managed in these type of buildings. I'd also like to mention the building is fully sprinklered, which will help the fire department to fight any kind of event that would happen. Thank you.
But you did not designate any places for this trash?
Yes, there is a trash room designated in the plan in the parking garage level. It's right near the lobby, right behind the elevator lobby. And they typically use a rollout. We've done other projects like this. They do more than one pickup a week and everything. We don't, by using private trash collection, it's much more manageable than the once a week municipal collection.
We
yes.
could touch on this further down the
Yeah,
line if
it's-
necessary.
It hasn't become a problem. Thank you.
Other councilors ready?
Thank you all. My name is John Turco. I'm the Ward 1 councilor, which is the abutting ward to Ward 2, obviously. Goldwaith Brook obviously travels through my ward, and any interference with Goldwaith in this area would then cause issues for us in Ward 1. So flooding is a big concern. But I did come here tonight with an open mind. I wanted to hear how they were going to mitigate the flood concerns. Right away, they lost all credibility with this area doesn't flood, because everybody in this room knows that it floods, and obviously they're not aware of where they're working. So at this point, I look at their own presentation. They mentioned in the presentation that they've got some mitigation efforts in the works. They mention the parking underneath won't be enclosed in the event that it does flood, but yet they state that it doesn't flood. So which is it? I'm confused. For the better part of a half century, the city's attempted to ease the flooding situation in this area, yet they want us to believe that they've solved it in 4 years. They also mentioned that they're going to park vehicles underneath. These people, it's affordable housing. So these people are already behind the 8 ball financially, and you want to put their cars in a flood area. It doesn't make sense. Excuse me. It doesn't make sense to me. As Councilor McGinn stated, our zoning does not allow for residential construction in the area. For decades, we as a city have had to deal with the aftermath on the residents, and I don't fully believe that these people have looked at the long-term effects of putting residents in the damage that this city may be up against. Yet we, as the people that have written the zoning, are well aware of what we're going to have to face. And that is why we've repeatedly put it in our zoning that these areas aren't, suitable for residential. The traffic study, as Council Rosendale mentioned, 80 units, 36 people are going to leave for work in the morning. Where are the rest of the people? Where are the visitors? Where are the delivery trucks? Where are the pizza delivery people? Lastly, you mentioned Little's Lane. Little's Lane is a very narrow strip. You want to put an access gate there. Well, it's fortunate that you brought up the access gate, because we have a project in Ward 1 called Stonegate Subdivision, which has gone before planning. They wanted to put an access gate at the top of Pearl Road, where it meets condominium development. The police department, fire department, and the planning board all spoke adamantly in opposition to that access gate because of fear of life safety and immediate access to residents. So we're already aware that police and fire are going to come and speak against that, but yet they've put that forward. I'm just very curious how these third-party reviews, these peer reviews, will come back, specifically with flooding, for these people to make the indication or the statement that there was never flooding in this area, it's never been a concern. It means they haven't taken this seriously. They've come up with a plan that works for them, just like they've tried to circumvent this whole project, I'm trying to think of the word, from the beginning with the Conservation Commission. They went to the Conservation Commission in 2014. They were told that it was conservation land. They were told that it was flood land. As soon as they got that answer, they decided that they were going to pull back their applications and they were going to go 40B, because they knew if they went to the traditional method, there was no possible way that this could be allowed in that area. I think this totally flies in the face of what 40B is supposed to be. I don't think that, when you don't get your way or when it doesn't work, that you go 40B. I think that there's reasons why the zoning is what it is, and they were well aware that the project in the traditional manner is not going to work. but yet 40B is the answer because they could circumvent all the safety mechanisms put in place to defend our residents and to help our residents. Thank you for your time, and appreciate it.
Any other councilors? Okay. No more councilors, so how about abutters? Anybody in the audience that wishes to speak in favor of this? Any abutters, neighbors that wish to speak in opposition? Please come up, state your name and address for the record. Do we have more than one? Okay, you can line up. Just keep in mind that if the person before you says exactly what you want to say, you could just state your name and address for the record and say, I agree with everything my neighbor said.
Richard A. DiFilippo. I moved to Peabody, I would say 6 years ago. And in that 6 years, I love where I live, except that I keep coming up before this honorable board with these people trying to build a massive structure in back of my house. I share a right-of-way that goes to the Elks Hall, but I share that right-of-way. It's deeded with the Donahues, who live next door to me. And I know that when I speak to Judith, we're not in favor of this, because this is going to be an access way for people to walk up and down. It's going to crowd the area. I can't even get out of my driveway onto Washington Street sometimes without being in fear of my life from the traffic. And I just can't imagine what kind of traffic this venture is going to bring to the area. I mean, it's just inconceivable. I can't conceive of anything like this. I don't know what else to say. I'm just not in favor of it.
Could you just give us your address?
My address is 41 Washington Street.
Thank you very much.
My name is Jacqueline Santiago, and I'm at 42 Oak Street, so I am a direct neighbor, and I would share a driveway. So the house that you can see in the picture it's my property on the first picture that they put up. And so we have parking on the side of the house that we park 3 cars in, and we have a parking on the back of the house, and so we share the entrance with the Elks to our parking to the side and to the back. So just wondering how that's going to work for us with 124 plus cars coming in and out of this place. And with the Oak Street traffic, I usually sit in my driveway for about 5 minutes before I can get out at 8 in the morning to go to work. So I can't even imagine another 36 cars. But so it's, yeah, we're very against it, and it's very upsetting because they're not taking any of us into consideration, especially with making us come here every single time that they change the date. So just, thank you. Thank you.
My name is Tom Crean. I am a member of the Peabody Lynn Lodge. I've had the pleasure of being, quote unquote, the exalted ruler for 2 of the last 4 years. And as far as flooding, last August, myself and 2 members were in there at 5 in the morning on a Monday morning, shot backing up the water just to get the place open by 10 o'clock. There would have been a lot more members here tonight, but they have a meeting that they would not allow them to skip, so this is why I'm the Lone Ranger. The people do not want to leave. I don't know if anybody's aware what we do. We have given scholarships out. We've gotten grants for No Child Goes Hungry. We gave a $2,500 grant to the Welch School Summer School Reading Plan, and as a lifelong resident, the only time I've been gone out of this city is the 3 years I was in the service, from 78 to 81. I can't see the traffic that this is going to put on us. It's bad enough down the square as it is. And the emergency people trying to get in there, because I've seen the fire trucks trying to get in. That's why we leave the back gate open. And I thank you all for letting me speak.
Thank you, sir.
My name is Dina, and I've lived on Little's Lane for 14 years now, and probably going to reiterate a lot of what has been said, but yes, the traffic is unbearable, and it's only going to get worse, and there is tons of traffic. Washington Street is nuts, backed up in the mornings, trying to get people coming from Aborn, trying to get down Oak Street, and with the businesses on Oak Street, with the trucks backing in and out, that stops cars from coming down Oak Street, so that makes a lot of backed up traffic. And then for Little's Lane, I mean, we don't have sidewalks on Little's Lane. So anyone trying to get out onto Little's Lane, and if they're not going to block the cars coming out from this, that makes it even more treacherous for people. So those are my biggest concerns, besides the water, because I've been here, and that Mother's Day storm of 2006 was out of control, so we know about the water. And just, I think, it's just too big, just too big. So those are my major things. Thank you.
Thank you. Anybody else to speak in opposition? Okay. Explanations or rebuttals?
Well, I mean, there was a lot discussed tonight. I think there are a lot of good questions that were raised and a lot of issues that we'll have to examine both on our side and also with the board's peer review consultants and professionals, and we're happy to do that. I think there was a misstatement in terms of flooding. Yes, we understand that. We've seen some documentation of that, and we intend to comply with applicable performance standards to make sure that it doesn't become a health or safety issue. And so we look forward to working with the board on those items. And it wasn't our intent to respond to every single issue this evening, but I think we'll put together written responses and then take the next step and have discussions in terms of all the various issues that were raised. And again, I mean, most of the issues that we heard tonight, we'll be happy to address and work with the board on. Thank you.
Okay, so at this point in time, I believe we're going to schedule the next meeting. So here's the thing. Our next meeting was to be held December 2nd, although it isn't because we have a couple of members that can't make it. We then thought maybe we would have it December 9th. We can't do that either because we have a couple of members that can't make it. So it looks like right now our next meeting for the 40 Oak Street Development LLC will be January 13th. You can make that, Ed? January 13th will be the next time we meet. And no meeting on the 6th because that is the inauguration night here. And that about wraps it up, folks. Yep.
If I may say one item, that's fine. We'll request the board to continue to January 13th. The only question is between now and the 13th, if, as discussed, we can have the dialogue with Mr. Bellavance, Mr. Beals, and the professionals to make sure we have all the scopes squared away, and we'd appreciate that happening between now and then so that we could get moving on addressing some of these issues.
And you obviously know how to get in touch with Mr. Bellavance?
Yes.
And his contact information, Mr. Beal? Okay.
Yes.
Motion to adjourn.
Thank you, everybody.